I'm Carly Easton and I'm moderating this session. I'm excited to announce this didactic titled Law Enforcement and the Emergency Department, an overview of relevant considerations, laws, and policies. And this is a panel. I'm going to introduce the first speaker of the panel, Dr. Hannah Janeway from UCLA.
Hi, thank you guys all for joining us today. We're going to get started pretty quickly because there's a lot of content to cover. I'm Hannah Janeway. I'm an emergency physician and fellow at UCLA here in Los Angeles. I have my colleague Shamsher Semra here as well. You can introduce.
Good morning, everybody. Yeah, I'm a ER physician attending down at Harbor UCLA.
And Jisun Song, who's a lawyer who's done a lot of research on this particular area of law.
Hi, everyone. I'm currently a teaching fellow here at Stanford and will be joining the UCI law faculty come July.
So just really quickly, the objectives we're going to cover in this talk. We're going to go over the larger social context surrounding law enforcement and police and hospitals in general. We're going to talk about structural competence and dual loyalty. We're going to go through some cases and talk about legal standings and implications of those different cases. And then we're going to talk a little bit about where to go as physicians from there through a pragmatic and liberatory solidarity lens. So I'll turn it over to Shamsher.
Great. Yeah, so if we go to the next slide, why is this important? I think it's important that we start with a very patient-centered perspective and recognize that different patient populations have negative perceptions of law enforcement, which may be different than our own. And this has negative implications for healthcare access and basically healthcare delivery. This 2020 study basically shows that across different groups that they looked at, there was different levels of mistrust of the medical system. You can see that's on the y-axis there. The other interesting thing is that as people kind of go to the right on the x-axis there, meaning more negative encounters with law enforcement, that correlated with a negative perception of the healthcare institution. So it's important to recognize that. And if we go to the next slide, we see that this isn't, an isolated type of thing. This is borne out in multiple other studies where interviews with victims of violence, individuals who are undocumented, the homeless populations, basically shows us that presence of law enforcement in healthcare institutions is a deterrent from accessing healthcare services. If we go to the next slide, it's important to recognize that we can't consider our relationship and the presence of law enforcement in healthcare settings as kind of the way it's always been. We have to go back and do a little bit of a historical and structural analysis to recognize how we became so intertwined with the carceral infrastructure. And in doing that, we recognize that the United States is infamous in our carceral project. We have 5% of the world's population and about 25% of the incarcerated population, which is about 2.5 million individuals, about 10 or 11 million people passing through these carceral institutions every year. If we go to the next slide, we know that the impacts of policing and incarceration aren't borne equally across all individuals in this country. It's a disproportionate impact on communities of color, particularly Black communities in the United States. If we go to the next slide, we also recognize that the impact isn't across all class groups, equally manifested, where poor communities are by far more impacted by policing and incarceration than more affluent communities in this country. Go to the next slide. This is kind of the last point I'll make on this, and is to demonstrate that the current status of kind of policing and incarceration isn't, the way things have always been. It's a product of policies, largely state policies, that have contributed to, this process of mass incarceration since, the late 70s or so. And if we go to the next slide, we have to recognize that it isn't just kind of prisons and jails is where all these resources are being invested. This massive investment in incarceration and policing has significantly modified the geographies of our cities and our states. And to demonstrate that, I'd like to basically use the case example of Los Angeles, where I work. And to do that, I wanted to kind of back up all the way to kind of the early 20th century. But before I do that, the red parts of this map come from the $1 Million Hoods project, or the map comes from the $1 Million Hoods project. The red portions basically demonstrate the regions of LA where the most amount of money is dedicated to policing and law enforcement. But if we back up all the way to the 1930s and 1940s, we know that there's a large influx of folks coming from the Jim Crow South to seek economic opportunities in the war industry. But once World War II ended, if you hit the next button, Hannah, a lot of those military and aerospace jobs left Los Angeles County. If we hit the next slide, what left with them is basically white communities, more affluent communities, as they left the inner cities. And this is a trend that happened in probably the city or state where you work as well. This was reinforced by racist redlining policies that folks are probably very familiar with. And with that, if we hit next, what we have is a flight of social services, including medical services, primary preventative care, and we have basically concentration of poverty and kind of racist practices. Going into the 70s, we have another migration of folks coming from Latin America related to economic military interventions in that region. And then we have deindustrialization, basically again, loss of jobs to other countries. And again, we have more concentration of poverty. We have a lack of social services in these areas. So with all these social issues that have been created, the response wasn't to invest in healthcare services, to invest in supportive services and wellness. Instead, it was to invest in policing and law enforcement. And we have the war on drugs and all the other things that folks know about. So this is basically how we come to a place where, if we go to the next slide, depending on where you live and which hospital you go to, your likelihood of being engaged by law enforcement is significantly different. So if you're in West LA, likelihood of encountering law enforcement when you come to the emergency department after being in a car accident is very different than if you come to South LA, and we have to recognize that. And this has had significant manifestations on life expectancy. Go to the next slide. Income inequities that exist between regions. If we hit next again. And it takes us to the point where we're at right now in our contemporary moment, where depending on where we work, there's a good chance that we may be working alongside or be in the presence of law enforcement. And we have to recognize that this has impacts on the way we provide care. And it's this idea of dual loyalty. And dual loyalty kind of refers to this fact that once we have a third-party entity that's present, in this case, law enforcement, it can, at various levels, either subconsciously or consciously or through policies, affect the way we provide care to our patients. The World Medical Association makes it clear that the obligations of the healthcare provider are to the patient, and we should provide our full technical support to our patients with moral independence of this third party, meaning law enforcement in this case. But the World Medical Association also recognizes that despite all the precautions and preventions and cognizance we can have of this coexistence and the impact it has on our care, this kind of dual loyalty problem or dilemma still exists. In the next slide. So we have the dual loyalty problem. We have the vulnerability of our patients to law enforcement and the violence of law enforcement just on the basis of where they live and which hospitals they go to, the deterrence it causes for patients coming to those healthcare settings. And then also we have to recognize the racism and classism that exists within our institutions and the biases that are created just when someone happens to come in, in the presence of law enforcement, or law enforcement is coming and asking questions about a patient who may be suspected of a crime. So if we go to the next slide. Basically, I want to hand it over to Jisa now, but really kind of recognizing these dilemmas exist, it's important to think about kind of the legal and considerations we can have in kind of creating a better path forward.
Yes, and so recognizing first that this is a fairly complicated area of law, Also recognizing that I think from the medical provider physician standpoint, you might be more familiar with things like HIPAA than what you think might be constitutional rules down the line. But part of setting up our case examinations later on is to realize that the actions of physicians and other medical providers, though, have profound consequences for your patient's constitutional rights down the line. And so we set out just three primary buckets to, perhaps maybe simplify this a little bit. But from the federal standpoint, you have HIPAA, which has a strong norm of patient privacy. But you also have the US Constitution, which ostensibly has strong norms of individual privacy. And then you also have state laws, that state disclosure requirements that might exist, but there are also strong state norms about protecting patient privacy, as well as state constitutional laws, which are sometimes a lot more protective than federal laws are by design. But then you have at the third level, which is kind of these institutional rules, like both law enforcement rules and hospital rules that exist, that are kind of interpreting these. But we have to realize that some of these norms can get lost as institutions are trying to deal with each other and deal with complicated, nuanced problems. And the bottom line is to recognize that these institutional policies, though, can harm patients and have policies that are legally, ethically, and morally wrong from a physician standpoint, from a patient-centered standpoint. And to know that a physician's responsibility is to call out these deviations and to advocate for the patients specifically. And just kind of one more outlay, which we don't really talk about so much, but I do want that when I say that there's complications, there's both HIPAA and there's constitutional norms, but there's also a lot of state tort liability that comes into play here. And we will touch upon those, but this is a good, I think, framing for as I turn over to Hannah for our first case study.
Yeah, so what we did is we made some cases of things that we had seen in our daily practice, and then we also did some investigation on our own and found Jisun, who is luckily an expert on this, to try to help us understand what are our legal requirements and what, and do any of those really actually trump our moral and ethical obligations to our patient and to protecting their privacy. Because I'm sure you guys have had experiences like this, but sometimes the police have told me personally other things, like that I legally have to do something that actually I have now realized I don't legally have to do, and those actions could have actually caused harm to our patient. So we're going to go into the first case. We have a 51-year-old male brought in by ambulance after an arrest during a traffic stop for parole violation. The patient was struck with a taser and bit by a K9, and PD is requesting information regarding these injuries. They don't have a warrant. So what should you do? Should you provide PD with a clinical update? Should you refuse to speak to PD? Should you provide information that influences disposition and follow-up? Or should you contact the hospital privacy officer? I'm going to let everyone just think about this for a minute, and you can feel free to put your answers in the chat. And then go on to the next slide with the answer as we see it through our legal analysis, which is that you can provide information that influences disposition and follow-up, and you can contact the hospital privacy officer. And I don't know if Jisun, you want to add the legal analysis around this now.
Thanks. So if you think, so this is one framework to think about it. So one, with the first category is like, this is what the law enforcement has asked you to do. What are the potential rationales for that? So they might say, this is information necessary for investigation. The patient is either a suspect or a victim of a crime, and then that they're doing their job and that you're interfering with their investigation by not providing them with this information right away. Now, if you think about the potential legal frame to this, so just highlighting Hannah's point that law enforcement may say that they need something right away, but it is a moment for the medical provider and the hospital to think about, well, what are my actual legal duties? And so HIPAA prohibits clinicians from releasing information about patients to police without consent or a court order warrant, with narrow exceptions. And the thing about HIPAA that's interesting is that it's all permitted language, it's not mandatory language. And then if you also think about HIPAA has stringent kind of like decision-making trees that medical providers are supposed to go to before they release information. Patients should also have access to appropriate legal counsel at all times, even if this delays questioning, right? There's nothing the right to counsel at that point exists all the time. So they have that right, even if the law enforcement is saying that they need that information. And these rights are not suspended for patients who are under arrest or in custody. So hospitals and law enforcement should set up systems to facilitate that representation, because there have been times when police come in and then use the emergency room or other kind of hospital cases in order to do questioning that might otherwise be constitutionally suspect, but using that hospital space to say, hey, this isn't technically a police jail cell or anything, so we're just questioning, we're not actually interrogating. So you see a way in which this the constitutional rights are circumvented. And there's also potential tort liability for invasions of privacy, defamation, emotional distress, if you think about just this handing over of information. I will do a caveat for like state reporting requirements, which we'll touch upon later, but just to say that these state mandatory reporting requirements are also super narrow in what you're supposed to do. And there's also a contemplation, I think, by a lot of legislatures that there's supposed to be this formal pathway of reporting so that there's actually a paper trail. So it's not like a free for all, just give information whenever. And actually one of the hospitals I'm working with, we're coming up with like a boilerplate written form that physicians can fill out to take into account that sometimes this asking and pressuring to hand over information interferes with patient care at the moment. So how is it that we can balance to those two things? And a patient right-centered approach here would be to have patient advocates who are present to respond to any law enforcement requests, and that there are actually no law enforcement encounters with patients in the care settings themselves.
And I just want to add one option if you have a patient who comes in and is going to be transferred after your evaluation into police custody and they're requiring a medical evaluation. If there is medical information, say you prescribe an antibiotic or you want to do something but want to make sure they have continuity of care, one option that I feel very comfortable with is writing out, the discharge instructions or the letter and then putting it in a sealed envelope and addressing it to the jail physician. That way it's physician to physician handoff, and the private information doesn't get released to the actual law enforcement officer themselves. We're going to go to case 2. So 46-year-old male brought in after being shot multiple times in the torso. There's also a younger gentleman involved in the incident that's being seen in the ED as an ED trauma. EMS reports that they think this is a gang-related shooting. LAPD arrives with a patient and requests to speak to him and photograph his wounds and or any visible tattoos. So what should you do? Should you allow the LAPD officers to conduct their interview? Should you obtain consent to speak with the LAPD police officers? Should you ask the LAPD police officers to step out of the room to allow for clinical assessment? Or should you contact the hospital administration for guidance? And I think, the most appropriate thing is patient care first. So you should ask the LAPD officers to step out of the room to allow for clinical assessment. All these other things can come later. I'm gonna turn it over to Ji-sun about this phenomenon of law enforcement just wandering around in patient care areas or showing up.
Yeah, and so the law enforcement response or argument is that they're seeking justice, they're conducting an active investigation, that here there's for example, in the case study that we saw, that the person is potentially a gang member, and so, or that they might be a victim of a gang shooting or something like that, and that could extrapolate to other scenarios, and protecting the community, keeping the community safe. And oftentimes also the justification, I think, which we didn't add here, is protecting the ER itself, right? To keep this hospital secure. There's a lot of conversations about hospital violence, and that's the reason why police are wandering around these patient care areas. Now, if you think about this potential legal liability, the one I want to emphasize here is that medical providers and hospitals have a huge role here in like establishing what is actually private for the patient, because patients have an objectively reasonable expectation of privacy in the medical examination room. They also do in more private spaces. Now, I know in a lot of EDs, you don't have the same kind of like private room that a patient can go to, but at the same time, the way that courts interpret it are much more free for all than at least the EDs I've been to, right? Like the patient treatment areas are still much more private than they are in the waiting room, and certainly not as if they were on the street. Yet, unless, in the case law, what you see is unless the hospital, the medical providers have established this more private kind of space, the courts don't really interpret it that way. So here is like a major patient right-centered approach that you could employ, which is to One is to ban law enforcement presence in patient care areas of the hospital, and also to emphasize either in your hospital policies or even in the way you talk to law enforcement that these are spaces of care where all individuals deserve to feel safe and protective. There's a lot of sanctuary-based language that is going around right now about how hospitals should actually be sanctuaries for patient care so that we can balance both patient rights and also give law enforcement their ability to conduct their investigation, but not actually in that moment where you're affecting the patient themselves who's coming to you for care. So I had talked a little bit about this patient care versus public safety tension that you see in the law. So emergency room physicians and doctors generally have these socially imposed obligations, and there's all the child abuse, elder abuse, anywhere down to some states have very broad reporting requirements. And what I, again, I want to emphasize is that you should be familiar with the laws in your state, because the laws in your state will have what is required, maybe it may be in the name and like the initial cause of injury, but you find that medical providers may be pressured to give even more information than that under this justification, and that just should not fly. The other thing to realize is that there is nothing in these things about, like, there's some of these statutes talk about immediacy, and I think law enforcement then decide that immediacy means like in the trauma bay at the moment. I don't know if the court legislate, I think it's, and what we've been doing and pushing back with some hospitals saying immediacy means as soon as practically possible, right? But that doesn't mean that it's at the moment when you're resuscitating a patient. And so we've been advocating with hospitals to develop some kind of, as I said, a protocol about how this reporting might happen. And when I said the thing about paper trail, the reason why the paper trail is important is oftentimes later on, a law enforcement may say to someone, oh, it's because of mandatory reporting, and then that we were able to get all this information, but there's no way for your patient to actually challenge this later unless they know who said what from the doctor or from the hospital's perspective. So, anyway, so that's the note that we want to talk about, that I wanted to say about that.
So really just a summary from slides 1 and 2. Ask law enforcement to step away or out of the room. There's really limited sharing of clinical information in the ED. Like Ajusan said, it's state dependent a lot of times, but it's very limited amounts. It's usually just name information, maybe date of birth and status, like if they're stable or not, but you have to check your individual state. And then ensure clinical information is sealed or secured at discharge, kind of like I was speaking about after the first case. Just a small little note on mandatory reporting laws. Those laws are actually being challenged by a lot of community activist organizations and others because they tend to really oppress, in some cases, marginalized or vulnerable patient groups. And so just keep in mind that, while we see them a lot of times as ways to protect patients, there are a lot of communities who actually see them as a method of oppression itself. So this is
Hannah, can I just say one thing?
Yeah.
Sorry about that. The other thing about that is social workers, other people who are mandatory reporters get a lot of training on this. How do you mandatorial report without getting your implicit biases in place? And that is something I think medical providers don't get as much. So think about that as well. And then I got a question through chat. So the rationale for a lot of this is that there's some active live investigation that requires this immediate kind of information to be turned over to police. So I practiced in criminal law for a decade before going into academia. The thing is that there is very little research, and probably research that shows that this kind of immediacy does not translate to solving crimes actually, and that there is also ways in which hospitals can, for example, the Boston Marathon bombing case, right? There are certain types of situations where there's actual emergencies where the police officers are able to get that kind of information. Right now, what we're saying is that there's almost too much of an emphasis on giving this kind of information, thinking that there is some kind of overall public safety benefit when actually the balance has completely outweighed the interests of the patient, and arguably don't really protect all of us in public safety as well, if you think about how this leads to mistrust of patients coming to healthcare settings like EDs. So sorry, Hannah, I just wanted to say that one thing.
No, thank you for mentioning that. I think it's very true. This is just to say that, you know, ACEP actually has put out a brief about law enforcement information gathering in the emergency department, which basically echoes what we have just discussed here. We're going to move on to the third case in the interest of time. So we have a 44-year-old male brought in after motor vehicle collision. He's suspected to be intoxicated. He has a low GCS and is intubated for airway protection. He gets pan scanned, which shows a bunch of injuries, including rib fractures, a splenic lac, some pulmonary contusions, and a law enforcement officer requests a blood sample for an alcohol level. They clarified that the patient is not under arrest. You should. And, you know, you should request a warrant or seek guidance from the hospital chain of command. This is a little bit complicated. Jisun's going to take us through it because of some state laws, but yes, you should request a warrant.
So if patient agrees, then that there's different kind of scenarios, and this might be vary amongst jurisdictions, but as you can see here, we've given a chart of like what are some of the decision-making pathways you should make. So if the patient agrees, obviously there's no issue there. There is sometimes an issue of like forced consent, which I know sounds like an oxymoron, but like that is often how these blood draws happen. Like the patient doesn't feel like they can refuse. But let's say if a patient refuses, then you should be trying to get a warrant, and you cannot use excessive force or violence to obtain the sample. Now, if patient is unable to consent, a warrant is required, and also the same applies. I don't know if Hannah, you had more specifics that you wanted to say here. I think the one thing that I might say is that physicians shouldn't forget the kind of analysis that you have to go through in order to conduct a kind of medical procedure when a patient refuses or is unable to consent. You have your own set of rules that you must follow, and that the law enforcement ones shouldn't trump this. And the other thing about this is that even if you're given a warrant or a subpoena to do something like a blood draw or a cavity search, the case law is very clear that a physician can, if they don't think it's medically necessary, or if your own ethics tell you that you don't want to do it, then it's not, this warrant or subpoena is not binding on you. So that's the last thing I wanted to say. And Hannah, I don't know if you wanted to add anything about that.
No, I mean, I think that covers it really. I mean, we're not police, we're physicians, and to do anything without patient consent is actually assault on the patient. And no matter what the police says or how they try to intimidate you, they do need a warrant. And you also personally can refuse if you think it might be dangerous to the person, or you would have to sedate the person or do anything extreme to the person in order to obtain the sample that they're requesting under a warrant. Many times they will send their own people to do these sort of things, like draw blood. And, you know, I personally would only feel comfortable in that particular scenario.
I'll just add a little caveat. Some states like California do have implied consent, but still implied consent, meaning that, you know, when someone gets a license, they consent to having their blood drawn, but that doesn't compel the provider to draw the blood against someone's will. But just to recognize that caveat does exist.
Yeah, and even in California state law, technically you have to be under arrest for that law to go into effect. So these are very nuanced laws that unfortunately in every state you're going to have to look up on your own. This is just, you know, a pretty good article that they published on an ethical analysis about law enforcement and emergency medicine. And, you know, it shows that, you know, one of our own intubated a patient and to perform a rectal exam, which is extremely concerning to me. So just to hit on the point that, you know, we owe our responsibility to patients, and doing something like that is assault. Case 4, we have a 44-year-old brought in after a GSW. They're intubated and redlined to the OR. The patient's clothing is inventoried and secured by the hospital, and now the PD is requesting access to clothing. What should the providers do? Same sort of thing. We're going to talk a little bit about chain of custody here, but you should request a warrant. So I'll turn it over to Jisun now.
Yeah, so just some things to keep in mind is that they're both from the hospital and the physician's perspective in order to maintain chain of custody, but there's also something else called probable cause. The one which is what is needed in order for your Fourth Amendment rights to be abridged. Now, the requesting warrant is the best way to go, because how is it that you as a medical provider are able to assess whether a law enforcement officer has a necessary probable cause? So we have three ways of thinking about it. So if you can go to the next slide, is to think, so in this case study, the hospital had an inventory, and most hospitals have some kind of inventory policy that talks about how to collect patient belongings. And giving it to the officer in the moment is allows the kind of protections that you might see otherwise about for a warrant or a subpoena, or even to have some other person checking to see if this is actually hinged to a crime or an investigation, and that's the reason why the law enforcement are collecting it, that you are circumventing that if the hospital is simply giving it over. Now, the law enforcement rationale may be that they need to enforce the law, they need to collect the evidence right away, but the potential legal liability is that you are the hospital with you are basically abrogating the patient's Fourth Amendment rights by saying, I'm a third party and I'm just giving you consent to have you searched. Now, I think it's if a hospital has inventory policies, that is arguably that is arguably unconstitutional, because hospital inventory policies are to be secured for the patient. The clothing is to be secured from the patient, and so sharing this kind of evidence for criminal investigations in concert with law enforcement opens up physicians to a Fourth Amendment state actor liability can of worms. Now, a patient right-centered approach is to maintain patient privacy and trust, and also to clarify that the inventory policy for the hospital is for the purpose of securing the patient clothing for the patient, and not securing the patient clothing for some other third party to access. Now, again, the warrant requirement allows police officers to be able to get it later on, just like not in the moment, and with not creating this kind of like legal paper trail that allows things to be properly reviewed in court. Now, the next slide is like, let's say the patient's possessing drugs, and let's say for contraband purposes. Now, there is still the law enforcement response may be for enforcing law now, and that this is an illegal substance. There is still constitutional liability for that. Physicians are liable to the extent that you are helping or sharing or collecting and sharing this evidence for criminal investigation purposes. And the other frame to think about this, though, is that you don't want to be in the position where you're placing yourself in the role of patient and saying, I'm consenting to the search, which arguably you are doing. Now, a patient's right-centered approach would be that when law enforcement, drugs should not be criminal. Well, I'm not quite sure, Hannah, maybe you can jump in and say what this first bullet point is. But that patients, if you think about how drug use is seen from the health community versus how it might be treated by the courts, patients should be offered care and access to support services that they're desired, and their drug use should not jeopardize their access to health care. And I don't know if you want to jump in.
Yeah, the first point comes from, this working group that we have, and really this idea that, hospitals should be places where people come to get health, and that addiction is a real medical problem. We don't want to be in the position of criminalizing of drugs at all, or having people have people be arrested because they arrived to the emergency department with drugs, because that will make it so that it's no longer seen by the community as a place where people can go who have addiction issues. And so really, this decriminalization of drugs inside of the hospital, I think, is a pretty important thought about making hospitals really a place where people can get help and treatment, and not a place where they fear they might get arrested.
And the last point I want to make is that sometimes this possession of drugs is the rationale that law enforcement might give to ask a physician or someone else to do a cavity search, so a rectal exam or other kinds of procedures, even with a warrant. And this is often, I was surprised when I was doing this research, like how many times these cases showed up where nothing was ever found. And to recognize that this can sometimes be used as an intimidation tactic towards certain types of people who show up on law enforcement radar over and over again, and that you play a role in whether this kind of conduct is seen to be legally problematic. It is problematic, I think we would all say, like if someone undergoes like 8 different kinds of procedures, nothing's found and they're slapped with a $10,000 bill, right? But there is a role that physicians have to play to make sure that something like that doesn't happen anymore, both in the moment and then by making it so that patients are able to recover some kind of recompense for that kind of unconstitutional and really horrific actions. Now, if this is, one comment I just got was to turn it over to your security. Now that's fine, except when your hospital security doesn't have clear lines of control between hospital security and police. So one hospital I was dealing with, the hospital security officer tells this trauma surgeon, oh, when you're in the room, I know your boss. But when you are not in the room, then the police officer's boss, which is interesting when the hospital security is an employee of the hospital. So it's really important for you to know, or just like to not take for granted that just because you're giving it to the hospital security, that somehow means that you're employing a patient-centered protective approach, because there might be informal guidelines or informal understandings between your hospital security and law enforcement that means that that protection is actually ephemeral. Now, another question that I got is that, yes, so there's the issue, and I think, Hannah, you should take this about like staff feeling uncomfortable that they're breaking the law if they like lock up illegal items that are found on patients. And I know that UCLA has dealt with this issue. So maybe you can take this question before I go to this next.
Yeah, I think a lot of, what I'm going to say is kind of similar to what you said. You have to have good policies because there is this whole chain of custody issue with drugs or paraphernalia or other considered illegal contraband. So whatever the policy may be, for me, best practices is that it doesn't involve the police at all, because as soon as it involves the police, then they want the name of the person and et cetera, and they could press charges if they wanted to. So one of the things that we've been working on is just a Dropbox sort of method where we drop them into a box and then there's a company or security company that goes and empties the box out. That way, these items that are considered that are illegal under state or federal law, those items are then put into this Dropbox, and then that Dropbox is then like a locked Dropbox, like they have at the airport when you go through the security detectors and you bring something that you're not allowed to. And then a company, contracted company, usually it should be a security or security company, comes and takes those and brings them to a contraband dump site. And so that's what we have found to be possibly the best solution, but you have to be really clear in your hospital policy about how that is going to work.
And if you think about, I mean, sometimes I don't know if you're listening to this and being like, oh, that sounds so kind of like odd, but if you think about the firearm amnesty programs that most police departments do, it's not that dissimilar, right? So, and if you think about the flip side, like if you didn't do this, then you're suddenly turning the ER or the patient care setting into a place where you are in this action of recovering evidence and turning over evidence to the police and then instigating a criminal action. And a lot of times these are low-level offenses where maybe the prosecutor doesn't end up charging, but then you've gotten them 2 days of jail. And everybody, I mean, I'm sure all of you know, if you've practiced with a particular demographic, that even 2 days of jail can be enormously destructive on someone's life, especially when they don't have access to funds and they've lost housing, they've lost their jobs. So part of this is kind of like the overall context, I think, about why policies like the one UCLA is contemplating is so interesting. Now, this last is patients believed to be using drugs. And I think this is a much this is an easy call, right? So Ferguson versus City of Charleston was actually probably the one Supreme Court case that deals with these kinds of issues head on. And that's when this nurse contacted the prosecutor's office and police in their jurisdiction, was like, hey, look, like, what if pregnant women are using drugs when they're pregnant and it'll harm the fetus? So then they developed this program where they're drug testing these women, like, immediately after giving birth, and then hauling them off to jail. And this was found clearly unconstitutional by the Supreme Court. And oftentimes this, like, believed to be using drugs is, I think, is much more an issue where a much clearer area where physicians can say, this is a patient and a health concern, not a law enforcement concern. And to cross over that line crosses also over into Fourth Amendment liability territory.
So we have two more cases that I'm going to go through really quickly. The first here deals with a 19-year-old male who was arrested after running from police and sustained some injuries, including stating he was assaulted by police. The patient who appears coherent is refusing medical examination. You formally run through each of the components of capacity assessment and determine the patient has capacity. The police, however, are requesting the patient be medically cleared for booking. What should you do? So patients still have their rights, even when they're under arrest. Some rights are temporarily suspended, but the majority are still there, and the patient can refuse medical care. So you can have the patient sign an AMA form if you feel uncomfortable, or discharge them if you don't. And you can provide law enforcement information regarding the desired follow-up, as we discussed earlier, in a sealed envelope. Case 6 is Miss GP, who has a history of schizophrenia brought in by the police, who sustained a distal radius fracture and wants to file a complaint against the police. What should you do? Now, this I don't actually have a good answer for, because currently in our system, there is no good answer. But I do want to say there has been one study about this in the emergency medicine literature that showed that most of us have managed patients who have been victims of police violence, and the majority of us have not reported it. And most of us work in hospitals where there are no policies about how to report it and have had no training. And so I think the real important point in this is that we really, as physicians, need to start thinking about how we can assist patients who might be victims of police violence. Currently, most people, in order to report violence, have to go to the police themselves to report a complaint. Are there other ways that we as physicians can start collecting data that documents the frequency of police violence against our patients without compromising their privacy? And can we assist patients in getting connection to legal services or third-party entities where they can make complaints? This is just to say the government has not been interested in collecting this data, so it is not there and might be on us to collect. And these are just some ideas about what we can do in terms of when we see a patient who is a victim of police violence. I think one of the biggest things we can do is document the injuries well, because later on, if this person then were to file a complaint against the police department, if we did not accurately document in a way that we should all the injuries, then they might not be able to bring a case against the police. So document injuries, consider observation of the patient, consider independent reporting. In Los Angeles, there are some independent reporting agencies, and we should do some advocacy for mandatory reporting on a national level. I'll turn it back over to Shamsher.
Yeah, thanks, Hannah. I'll try to wrap it up and hopefully leave a couple minutes for questions. But if we go to the next slide, I just want to kind of zoom back out a little bit. We can go to the next slide. Basically, I want to talk about a case that we had as we were having these conversations about law enforcement in healthcare settings. We basically had a case where law enforcement killed one of our patients who was on a psychiatric hold. It was the second time in 5 years that law enforcement had killed the patient within our hospital. And what I really want to raise is, the first time around, and Hannah can speak to this, there was, legal payout, but really not much change at an institutional level outside of maybe some task force and maybe some evaluation of policy. So if we go to the next slide. I want to raise kind of this distinction between kind of humanitarian kind of responses and kind of the local level interventions we can have, which includes, the policies that we talked about here, which kind of are essential in terms of limiting the presence of law enforcement in care settings and protecting patient rights, psychiatric response teams, et cetera. But then if we go to the next slide, we still have to recognize that all of the things that I mentioned in the beginning, that we can try to protect patients, but still we have this structural failure where law enforcement is basically ever present in our care practices and intertwined in the way our systems of care function. So we have to begin to engage with that as we're developing these local level policies and enforcing them. So if we go to the next slide, basically what followed from this is an effort to connect our local enforcement of patient protection and limitation of law enforcement in care settings with local efforts to reshape care systems and limit kind of investments in the carceral system in Los Angeles County. So by connecting these two movements and organizing efforts, I think we become more impactful. And basically what's followed is not only are we pushing forward policies to protect patients in care settings, but we're also talking about, let's look at the contracts. Why is it that we're funding the sheriff's department to be present in these care spaces? How do we remove some of that funding and invest it into alternative practices, like some of the ones that we've talked about in this presentation, whether it's kind of peer navigators who can be the go-betweens, or patient advocates who can be go-betweens between law enforcement and the patient, or whether it's community-based kind of systems of care and safety. And it's only if we kind of work at both of these levels that we'll truly get to a point where patients can feel safe and feel that the hospitals that they're presenting to are there to promote their health and best interests. And with that, I think we can wrap it up with a few minutes left.
There was a question in the chat about what are the barriers, legal, clinical, or institutional, to banning law enforcement. In my experience, it has been largely institutional, pressure from police departments and the pressure that hospitals feel about banning. And then obviously what happened in Salt Lake City is that then a nurse got arrested, and so then the hospital ended up creating a pathway, right? So saying, like, not that, I don't know if they've been banned from care areas completely, but they've said you have to check in and let yourself be known. So like almost like realizing that police are visitors in patient care setting areas, and so we're going to create a pathway so that we know why you're here, and so that managed, I think, that situation in Salt Lake City. In the places that I've been talking to, I think largely the pushback comes from hospitals, right? Like they're like, well, we have this good relationship with police departments. We don't want to jeopardize that relationship. I think a lot of the conversations have to be like, it's about balancing these two considerations, not about taking one side versus the other. And so talking, I think a lot of conversations with your hospital, whoever your risk management or your general counsel, or whoever it is that is the decision-making authority on this, and getting them to understand the problems about this. I just recently developed a toolkit with another working group that I can circulate if people are interested about what are the potential harms that come to patients by having police in patient care areas.
There was a question earlier in the chat that was sent just to me. So in my institution, officers always say they are not allowed to leave the room. I've asked in different situations, and nurses and other doctors are always on the officer's side. Also, local police is our hospital police. How would you navigate this?
All right. Well, I don't, Hannah or Ashley, I'm sure, do you guys want to take it or you want me to take it?
I've experienced the same thing, and I can say what I say, and then I'll pass it over to you for the legal analysis. But so really, there's no reason that you can't ask police to leave the room. I guess under extraordinary circumstances, if they really believe that the patient is completely insecure and might somehow escape, they could claim that, and especially if it's a patient who's in custody and under arrest. However, usually I just tell the police, look, I feel comfortable being in there without you there. I'll shut the curtain, but I won't close the door. But I do need to talk to the patient privately in order to provide the best medical attention that I can. Would you just mind stepping out for a few minutes? So I try to negotiate with them, but really the patient does deserve to have privacy. And so unless they can present a real reason that they think that they can't leave the patient's side, usually they, with some convincing, will leave the room, in my experience.
One thing I would add is, sorry, just briefly, I'd say, the importance of kind of working with hospital administration to Jason and Hannah's point, to not, create policies that make it so the onus isn't completely on the healthcare provider to be in these confrontational circumstances, which can be intimidating and challenging. So I think it needs to happen at all levels. Definitely, advocate for your patient at the bedside, but work with kind of hospital admin to protect patients and to protect providers from having to have these distractions while you're trying to provide care.
Now, from a legal perspective, there might be the distinction that Hannah and Shamshir are making between like people who are actually under arrest versus not, and arrest is the same as in custody, so prisoners who are under custody. In the latter situation, so if you're actually under formal custody, there are laws that say that that they have to be accompanied, right, by the corrections authority. Then it gets translated. This is when I talk about the distinction between institutional policies versus the law. The way the police officers and corrections agencies have interpreted is that, we're like have to be in line of sight all the time. So there is a rule for you as a medical provider and for the hospital to say, well, there are ways in which we can say we care about the security of an inmate here, but at the same time, you can step outside the curtain, you can step outside the door in order for us to have this private conversation. I also think that I'll stop right there. Yeah. Are we out of time?
I think we are. There's maybe one more question. What is the best way for students and providers to be informed about local, state, federal laws that apply in their areas?
Well, I found that they're kind of like a hodgepodge everywhere. You could go to, I don't know, there's actually, Hannah and I'm sure you want to take this because I'll make it too complicated.
Find your local legal expert. Go ahead, Hannah.
No, I mean, I think that's something that it's possible that we all need to come together and really put some resource together for everyone. I think the federal policies, they've been outlined pretty well. The state ones, I had to do a lot of my own work in order to inform the people around me to know what those are. And I think that's definitely an opportunity for people to come together to kind of outline what those laws are, understanding that they do change sometimes.
Okay, well, I think that's all the time we have, and thank you for really great informative discussion, and thanks so much.